Professor Barry Sullivan, thank you very much for joining our interview series. Let me start right away with the first question. In Trump's court, Nixon's constitution, you argue that Supreme Court's immunity ruling represents a profound judicial reimagining of the presidency. How does this expanding conception of presidential immunity, articulated in Trump versus United States, intersect with Donald Trump's populist vision of a personalized, extra-legal leader whose will is portrayed as overriding institutional and constitutional constraints?
Well, I think that the constitutional doctrine and the man have met the moment. The Supreme Court for the last 15 years has been expanding the constitutional power of the presidency vis-a-vis the other branches of government. And with the immunity that the president now has and the power to pardon those who assist him in the work of the government if they commit crimes on his behalf, he has virtually total control without suffering any consequences. The expansion of executive power has been justified in part by the fact that the primary check on the president is the impeachment power of Congress. And if we consider the current situation where all three branches of the government, well, we shouldn't say that with respect to the court, but where both of the popular branches of the government are in the hands of the same party, and we have a party that is very tightly constructed in the sense that it's not a party that is a big tent in terms of ideology, but is very much aligned with the president, then the president has virtually total control because the separation of powers does not work as the framers anticipated. So I think that given the proclivities of the president and the latitude that the court has given him, the president has very, very broad powers at this time.
Right. To what extent does the court's new approach to presidential immunity signal a structural shift toward what you describe as a Nixonian theory of constitutional authority, and how might that shift accelerate democratic backsliding in the US?
Well, the Nixonian theory of the presidency was articulated by President Nixon at the time of Watergate, when he instructed his lawyer, who was arguing in the Supreme Court on his behalf, that the lawyer should tell the Supreme Court that the President of the United States had all the power of Louis XIV, except for 4 years at a time. In other words, there was no check on the president except re-election. And he further stated after he left the presidency in an interview with David Frost that if the president does it, it's not illegal. It is legal if the president does it. So I think that is, if I'm correct, that the decision in Trump against the United States gives the president power similar to the power that President Nixon claimed, which I think is correct, then I think that the opportunity for democratic backsliding is very great. And when you, as I said before, when you put together the very broad power that the president has, together with the pardon power, which allows him not simply to be immune himself, but in effect to grant immunity to those whose efforts on his behalf that he needs in order to do what he wants to do.
Right. Populist leaders often frame legal accountability as partisan persecution. How do judicially expanded immunity doctrines reshape the balance between democratic legitimacy and the rule of law, especially in the face of populist claims to majoritarian or plebiscitary authority?
Well, that's an interesting question. I think that the president, in terms of populism, that the president, in his campaign, in his last campaign for the presidency, um, repeatedly used the expression, "I am your justice, I am your retribution." And he didn't say retribution for what or against whom, but I think it was pretty clear that he was saying that he had been persecuted in the 4 years that he had been out of office, and that he was essentially persecuted on their behalf. And so when he came back to power in January of this year, one of the first things that he did was to pardon all the people who had been involved in the January 6th invasion of the Capitol.
Right. Does the court's emerging immunity jurisprudence risk creating what constitutional theorists describe as enclaves of unaccountable power? In your view, how would the framers, particularly those most concerned with executive aggrandizement, such as Madison and Wilson, have understood a doctrine that shields a president from criminal liability for official acts?
Well, I think that that this opinion, unless it is substantially narrowed in the future by the court, which of course is possible, but as it stands now, I think it does create an enclave of unaccountable power, and we've seen the use of that power in many ways over the last almost a year now. What would the framers have thought of it? I think that the framers would be absolutely aghast that the constitutional structure that they created was susceptible to this kind of democratic or Republican, they would say, erosion. The framers put a great deal of faith in the structure of the government, the separation of powers, and the checks and balances that were created. And we've seen that the checks and balances don't work in the way that the framers anticipated. One thing that the framers didn't anticipate, of course, was the rise of political parties. The framers thought that political parties, in the sense of standing parties that weren't just from time to time amalgamations of interests, but were standing political parties, were really a bad thing. And they thought that that we could get by in the United States without having political parties. Well, of course, this turned out to be wrong almost from the beginning. By the end of President Washington's time in office, political parties had already begun to form. Over time, political parties became more ideologically, I mean, this is really in the last 40 or 50 years, that political parties became more ideologically coherent in the sense that that you didn't have a range of views within the Democratic Party or within the Republican Party, but that the parties became more unitary in a sense. And I think that this is something that the founders didn't anticipate, and if they were around today, would want to do something about, because the development of parties has meant that the system of checks and balances and separation of powers doesn't work the way they intended it to work.
Your work on expert knowledge, democratic accountability, and the unitary executive highlights tensions between technocratic governance and populist distrust of expertise. How does the court's embrace of a muscular unitary executive model empower populist presidents to override scientific, technical, or bureaucratic judgment?
Well, I think that it does, in the sense that the unitary executive theory means that, as the court has interpreted it, means that the president has absolute control over the executive branch. And moreover, that the president must have control over all those who exercise executive power in some sense. So if we assume, as I think we should, that independent agencies exercise executive power in some sense, then the president has the power to overrule whatever an independent agency says. We created independent agencies, and they've been around really since the beginning of the Republic, but became more important in the 20th century with the New Deal especially. But we created those agencies because we thought that there were some areas of governance that shouldn't be totally dependent on the political will of the president. To the extent that the court has said that that the president should have power over these agencies, and we're going to see probably before the end of this term how far the court will go with that, because there are a couple of cases that are pending now to see what the president's power of removal over members of these agencies is. But to the extent that the president has the power to dictate what the independent agencies or the departments of government do, down to the smallest detail, then that is a problem for scientific and other kinds of expertise. We saw in the first administration, first Trump administration, that, and I think I detail this in that article, that the weekly morbidity and mortality report that the government puts out, which has been considered the gold standard in terms of reporting on health in the United States. And until the first Trump administration, was pretty much immune from political oversight, was the domain of medical scientists. In the first Trump administration, during the pandemic, we saw that non-scientifically trained people were given the opportunity to edit that morbidity, the weekly morbidity and mortality report, to mirror not what the latest scientific evidence was, but to mirror what the president's political strategy and political interest was. And if the court is really going to say that the president has that power, then that's very dangerous in terms of credibility of supposedly expert determinations by the government.
Right. During the pandemic, you emphasize failures not only of political leadership, but also of scientific bureaucracy. How do these failures complicate the conventional narrative that populist erosion is purely anti-expert, and what constitutional reforms might restore calibrated relationships between science and law?
During the pandemic, there were policy determinations that were made, I think, by medical experts that really were not the reasons for those, or the real reasons for some of those determinations were not made public. For example, there was a determination by the government that that people shouldn't wear masks at the beginning of the pandemic. And it turned out that that really wasn't based on scientific evidence. It was based on the fact that there weren't enough masks to go around. And the medical authorities decided that priority should be given to medical personnel having those masks. So there was a sense in which maybe that was the right decision from a policy point of view, but we were being told that it was a medical determination, not a policy determination. So I think those kinds of situations really reflected badly on the scientists involved. And I think that these questions of what is proper policy and what is good science, to a large extent, overlap, and we have to be told to what extent one or the other is being relied on. And I think that's an important. I'm not sure that it by itself is a constitutional problem, but certainly a legal problem and an administrative law problem in making sure that we separate those things to the extent that they can be separated.
In the landscape of democratic backsliding, how does the Supreme Court's revival of the unitary executive, combined with skepticism toward independent agencies, reshape the administrative state's ability to resist authoritarian tendencies?
I guess that's a wonderful question. I guess I would add to that picture, or to the hypothetical, the fact that the separation of powers between the executive and the legislative also is not working. But the unitary executive and the skepticism about administrative agencies or independent agencies certainly has an impact on the ability of government as a whole to withstand authoritarian tendencies. Because the president, under the unitary executive theory, has virtually unlimited power. And this president has demonstrated an incredible amount of energy. There is nothing that is too great or too small to capture his imagination. whether it is deciding that that we need to go to war, in effect, against Venezuela, whether we need to subsidize the friendly government in Argentina, whether we need to paint the executive office building white because he doesn't like the color gray, the natural color of the stone of the executive office building, or whether we need to tear down the east wing of the White House. There's virtually nothing to stop him. And I guess I would add to that the erosion that we've seen of what I would call constitutional conventions, not necessarily law, or at least in the sense of hard law, but soft law. The idea that there are some things that the president could do legally, but it wouldn't be within the spirit of the law for the president to do it. I liken the idea of constitutional conventions to the ligaments and muscles that propel us in addition to bones. We can't run with bones alone. We need these other things. And just as we can't, just as the rule of law doesn't depend exclusively on law, it also depends on this spirit of good faith and fair dealing that the branches of government that characterize the relationships of the
Right.
branches of government.
Right. Drawing on executive secrecy, how do secrecy practices, especially when coupled with expanded presidential immunity, contribute to the erosion of public accountability and provide fertile ground for authoritarian style governance?
Well, I've written extensively on the need in a democratic society for access to government information, and I think that access to government information is absolutely critical to any kind of citizenship or citizen oversight of government. I gave a lecture a couple of years ago in Bayreuth, and I put up on the board a picture of a drawing of the three branches of government, and each a little box. And then I drew a big box around those three boxes. And the big box is meant to represent the people. And it's ultimately the people that have responsibility for government. And without information, the people cannot monitor the government in the way that Madison, in particular, anticipated that they would and should in order to have a democratic government.
Right. Populist leaders frequently weaponize secrecy, disinformation, and institutional opacity. How should courts conceptualize transparency obligations in an era where executive power is increasingly asserted as a personal mandate rather than an institutional responsibility?
Well, I think that as a general principle, the courts have to insist that that executive power must be used as a means of institutional responsibility rather than personal mandate. I think that is one of the essential duties of a constitutional court in a constitutional system, is to maintain, or to, I should say, to ensure that the government acts truthfully and doesn't exercise executive power as a personal mandate or personal benefit, but really an institutional responsibility.
Right. In the Supreme Court and the People, you stress the court's communication failures. How does the persistence of opaque, fractured, and elite-oriented judicial writing exacerbate the populist narrative that courts are disconnected from the people, and what risks does this pose for judicial legitimacy?
Well, I think in that article, my co-author and I compared the way in which the Supreme Court of the United States communicates its decisions to the public. And that article is a little dated at this point because in addition to what we perceived as the problems that the court had at that time, which was that it didn't really provide meaningful press access to the court or summaries of its opinions that were user-friendly and so forth. In addition, in the last year or so, we've seen the court increasingly issue decisions in emergency situations without the normal the normal process of adjudication, in the sense of without extensive briefing, without time for deliberation, and often without any explanation at all. And I think that by virtue of that movement toward deciding many important issues in this summary way, in which I would say the justices are really given little opportunity to do anything other than decide cases according to their predispositions, then that's problematic from the viewpoint of judicial legitimacy. Justice Robert Jackson, one of the great justices of the court, who was also the lead U.S. prosecutor at Nuremberg after the Second World War, once said that the door you enter by often determines the door you leave by. In other words, if judges have certain predispositions going into a case, often those predispositions follow them out of the case. And the normal process of adjudication does everything possible to avoid that happening. Whereas when judges are required to make decisions based on very little in terms of briefing or records, very little deliberation, very little discussion among the justices as to what the outcome should be and why, then you're increasing the likelihood that the door you enter by will be the door you exit by.
Right. Given comparative examples such as Canada or Germany, how might improved judicial communication practices help inoculate the court against populist attacks that portray it as accountable, unaccountable, and politically captured?
Well, I think this goes back to my last answer about the way in which the court has started to decide really important questions summarily. But in addition to that, these other courts have taken steps with respect to the ordinary docket, the ordinary cases, to make sure that the people are given the means to understand what the court has decided and why. For example, in Canada, the Supreme Court of Canada has created this position, usually held by a law professor, who is available to tell the press on the day of decisions, to advise the press about the meaning of decisions, to answer their questions. And in Germany, a similar procedure where there's a lockup procedure where reporters who follow the court are given the opportunity to review the opinion before it's officially released, so that they can be more mindful in the way in which they discuss it for the public. And I think there's a recognition in both Canada and in Germany that the press has an important role to play, because most people learn about Supreme Court decisions not from reading those decisions themselves, but from reading what reporters say about the decisions. And so it isn't just the length or complexity of the opinion. In Germany, the opinions are perhaps even more complex and more lengthy than in the US, but it's other means of providing information to the public about what the significance and importance and meaning of the opinion is.
And lastly, Professor Sullivan, across your writings, there is a through line stressing how institutional arrangements can unwittingly facilitate populist or authoritarian trajectories. What combination of judicial, legislative, and civic reforms do you believe is most essential for reversing democratic backsliding in the US, particularly in a context where the court itself is increasingly central to transformation?
Yes, obviously a difficult situation, given the fact that, as you say, that the court has been central to the creation of the problem through this unitary executive theory. I'm not sure how much hope we should hold out that the court is going to back off of the executive, the unitary executive theory. And it's really a product of the last, the last 20 years, really. It's a product of the Roberts Court. In the unitary executive theory really came into prominence during the Reagan administration. Obviously, the seeds of it were sown in the Nixon years because of Nixon's views of the power of the president. But as a constitutional theory, it really came into its own during the Reagan administration, and particularly Attorney General Meese furthered this theory. I don't think it is really based in the founding. I think it is really principally based in the reaction that some people in government had to the reform measures that were introduced to limit executive power after the Nixon Watergate scandal. And virtually from the time of the Ford administration, Ford, of course, was Nixon's last vice president and succeeded to the presidency when Nixon resigned. And President Ford kept on many of Nixon's advisors during his term in office. Many of those advisors from the beginning thought that Congress was taking too much power away from the president. And so this unitary executive theory sort of saw its genesis then, really came into its own in the Reagan administration, but did not capture the imagination of the court. As late as 1988, in a case called Morrison against Olson, where the unitary executive theory is being advanced as a way of concentrating power in the presidency, the court rejects it. Only one vote in favor of the unitary executive theory, and that was Justice Scalia, who was one of the people in the Ford administration who thought that Congress had gone too far in reforming the presidency. But once Chief Justice Roberts becomes Chief Justice, and a group of people joined the court, Justice Alito, for example, Justice Thomas, who were very influenced by that theory as young lawyers. We see by this year a complete turnaround on the court, so that what was essentially a marginal theory in 1988 has now become the majority theory. As I say, I don't hold out a lot of hope for the court changing its mind about that in the near future. Clearly, if we had a Democratic president, I shouldn't say clearly, perhaps if we had a Democratic president and that president made nominations to the court, perhaps that theory wouldn't be quite so popular on the court. I think that the real problem is not a constitutional problem, but a political problem, in the sense of having a unified government, in the sense of the separation of powers not working the way that the framers intended for them to work, because of the fact of political parties being extremely polarized, and members of Congress putting party affiliation above all other affiliations in terms of their governmental duties. And until we can have a more balanced Congress, I think, we're not going to see a lot of progress. Now, one thing that we need to probably talk about before we end is the fact that President Trump has managed to persuade people that he won by a landslide. In fact, he won with less than 50% of the vote, and yet he has been acting as if he did win in a landslide. And in a sense, he did, but only because he controls Congress as well as the presidency.
Professor Barry Sullivan, thank you so much for your time. I appreciate it.
Thank you for the opportunity.